You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Bill, welcome.
Good day.
So we have a lot of court opinions to talk about today, but we're going to approach them one by one. First up, the highest court in the country and lower courts churned out several important bankruptcy opinions last week. Let's start with the United States Supreme Court. What did they teach us about bankruptcy law this time?
Well, they taught us that once in a blue moon, the Supreme Court can actually be unanimous.
Not something you see often with this court.
Not often, not at all, and this was a 9-0. It had to do with this really thorny question of what is defalcation while acting in a fiduciary capacity. Now, nobody cares.
What is defalcation? That's a great word.
Isn't that wonderful? Well, it actually is very important for a lot of ordinary people. Anybody who ever serves as a trustee darn well ought to pay some attention to this. Well, that's exactly the question. What is defalcation? Justice Breyer, in his opinion for the court, said, well, it's not all very clear because that's a word that the law just doesn't define. In fact, he had to go back to a Supreme Court case in the mid-1860s to find some kind of a case telling what defalcation meant. But let's just cut through all of this nonsense and get down to the bottom line. What he said was, if you are a trustee and you are accused of a defalcation, you cannot discharge that debt, you can't shed that debt in bankruptcy. So the question is, what does defalcation mean? Justice Breyer told us that it means that you either knew that the action you took was wrong, or you were in reckless disregard or willfully blind to the fact that you might be breaching a duty. Now, the question is, why do anybody care? Well, I'll tell you exactly why you should care. Take this situation, because this has happened in the past. Let's assume you have a law firm with 5 people, or maybe an accounting firm. You hold your customer's client's money in a trust account. And let's assume that one of your partners is a crook, and he or she steals the money. It had been held by some courts that the innocent partners who had nothing to do with it, didn't know it was going on, if they filed bankruptcy, they could not shed the debt. Now, that rule has been changed by this case called Bullock versus Bank Champagne. And for that reason, Lee, it's a very important decision which can make a trustee sleep a lot easier at night, because if your co-trustee does something awful, you ain't stung with it.
Yeah, important word, important case, and now an important concept for trustees and lawyers to be aware of. Moving on, we have a Judge of the Week, and it's Judge Cecelia Morris. You told me that she wrote the second most important decision in bankruptcy courts this week. Who won and who lost, and what's the case all about?
The public won. That's who won. The public won. And the notion of access to the courts. Judge Morris, who sits up in Poughkeepsie, New York, was presented with a case, actually a very large, maybe the largest Chapter 7 bankruptcy case ever. The parties in this case entered into a settlement for about $50,000. People, evidently, who were paying the money said, no seal, no deal. What that means was that if the settlement agreement were not under seal, in other words, kept secret, for 30 years, there was no deal. This went to Judge Morris, and on her own, she said, no deal. She said the notion of no seal, no deal, where parties by themselves can keep agreements in bankruptcy a secret, is completely contrary to notions of bankruptcy law and public access to proceedings in the bankruptcy court. Now, Lee, I am really ecstatic about Judge Morris's decision, because there is an increasing number of situations in bankruptcy courts where pleadings are sealed willy-nilly. And it just shouldn't be that way. Bankruptcy judges, frankly, ought in every instance to review pleadings to decide what is properly sealed and what isn't. In fact, Lee, I could, if I wanted to, have Bloomberg file at least one motion a week to unseal papers in bankruptcy court. The problem is, however, every time you do that, it costs maybe $30,000 to $50,000, and so it's just completely out of the question. I applaud Judge Morris, and I hope that other judges pick up on this. And by the way, if you want to find the case, it is named Togut. That's a name for Al Togut, who was a
famous
trustee.
bankruptcy name.
It certainly is. He was a trustee in the case, so if you fump it around, you can find it.
A bankruptcy judge from Houston wrote a significant ethics opinion that might have ended the career of a bankruptcy trustee. What was the sanction, and why was it so drastic, in your opinion?
Sad case, actually. Well, pretty simple, Lee. A bankruptcy trustee took a long weekend in New Orleans and charged the $3,500 of expenses to a bankrupt estate. And that, frankly, was just the last straw for Bankruptcy Judge Marvin Isgur in Houston. It is made worse, I guess, by the fact that the lawyer took his wife and his 2 kids with him for this long weekend. In some ways, maybe it's not so bad as it seemed, because his wife was his lawyer, and they were going to New Orleans, in this case, for an oral argument in the U.S. Court of Appeals for the Fifth Circuit in New Orleans. However, they flew down on a Saturday, or flew over on a Saturday, I guess you should say. Argument was on Tuesday. They didn't leave until Wednesday. And as I said, this was just too much for Judge Isgur, and he disqualified this lawyer from further service in this particular case. Now, that doesn't mean, Lee, that this chap simply lost this one little itty-bitty 2-bit bankruptcy case. No. Bankruptcy code says that if you are removed as a trustee in any case, you are automatically removed in every case.
Oh, dear.
Oh, dear is exactly right. And this is how this chap made his living, was by serving as a bankruptcy trustee. Methinks that there are probably right now a bunch of trustees in the world who are looking over their shoulder and saying, oh my goodness, have I ever charged any expenses to a bankrupt estate that might result in ending my career?
And Bill, according to your column, the U.S. Court of Appeals in Richmond found a gaping hole in the prohibition against lien stripping. What was the case about, and how did it come out?
Well, this is a really big deal for individuals, real people needing bankruptcy relief. It has to do with how you can get rid of situations where you have, let's say, 2 or 3 mortgages on your home piled one on top of another. That's where Chapter 20 comes into play. There is no Chapter 20 as such, but what you refer to that is a situation where first you file Chapter 7, followed a year or 2 later by Chapter 13. Here's the way it works. In Chapter 7, if you have mortgages stacked one on top of another, you can discharge the mortgages or the mortgage debt as your own personal liability. However, Congress changed the law a few years back so that you cannot simply knock the mortgages off of the property. In other words, once you go through Chapter 7, you no longer are liable to the bank for the mortgage debt itself. However, the bank later can come back and foreclose your home. Now, take this situation. Assume that the property is not worth as much as the first lien debt. You shed, in essence, the personal liability on all 3 of the mortgages in bankruptcy, and then a year or 2 later, you file Chapter 13. In Chapter 13, you are entitled to strip off these subordinate mortgages that are completely underwater, and the courts were, and still are, split on whether or not you can do this lien stripping in a Chapter 20 case. God bless the Fourth Circuit Court of Appeals in Richmond, Virginia. They held that Chapter 20 lien splitting is perfectly appropriate. They found it completely authorized by the language in the Bankruptcy Code. And if it's my guess, we're going to see many more of these Chapter 20 cases used where people get rid of subordinate mortgages that are underwater. One of these days, I think, though, we're going to find some circuit courts coming down the other way. And by the way, as you can guess, I think that's the reason this case is going to go to the U.S. Supreme Court. I should also mention that this was not a unanimous decision in the Fourth Circuit. It was a 2-to-1 decision. I think it's just a matter of time before we're in D.C. sometime watching argument on Chapter 20 lien splitting.
Right on. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our updates on Twitter. You can see more of our videos on YouTube. I'm Pacchia. Thanks for watching, and see you next week.